discovery and service of process. And that panel will study and discuss ways in which protocols for pretrial practice have changed during the pandemic. The third panel is on trials, witnesses, and juries. And then the fourth panel is a panel that is open discussion and forward-looking on the world post-COVID, and in particular, what innovations we should keep in the time once the pandemic is at an end. Before I introduce our moderator for our first panel, I do have a couple preliminary points. This conference is eligible for 5.5 hours of continuing legal education credit. That's 5.5 CLE credits in the area of professional practice. In order to receive CLE credit, you will need to submit a form. We will email you that form if you've registered for the conference within 24 hours of today. The form will ask you to include several codes. There will be one code for each panel. The codes will be given out during each panel, so please stay tuned for the code and write it down so that you can get CLE credit for each segment of today's conference. And then finally, we will be fielding questions through the Q&A box function at the bottom of your Zoom screen. If you have questions or comments, please submit them through the Q&A box, which will be monitored. Some of those questions might be subject to response in writing. Some of them may, the moderator may decide to ask them directly to the panel for further discussion. So let me turn to an introduction of our moderator for our first panel, which, as I said, is entitled Adaptation and Access to Justice, How Courts Respond to a Crisis. Our moderator is Professor Samuel Issacharoff. He is my colleague on the NYU faculty, where he holds the Ruiz Chair in Constitutional Law. He's also a faculty co-director of the Center on Civil Justice, and he is a leading expert in the country on civil procedure and in other fields as well. He was a law clerk for Judge Arlen Adams on the U.S. Court of Appeals for the Third Circuit and a graduate of the Yale Law School. So without any further ado, I will turn it over to Sam.
Thanks, Troy. It's a pleasure to be here. It's always great to do an event for the center, and we have to deal with the limitations of our era, which is the subject of our discussion today. By way of introduction, let me just say that as Troy mentioned, I'm also a law professor, and we spend a lot of time on the aspects of the courts that are useful for pedagogy. So we look at the opinions, we look at the way that the judges are selected, we look at things like that. But we tend not to focus enough on the fact that the judiciary is a huge institution in our society, responsible for not just the adjudication of cases, but oftentimes for the health and welfare of large numbers of people, be they detainees, be they children under court custody in some fashion. And that much as law students and law professors tend to gravitate toward federal law, state courts are 95% of our judicial system, and they are responsible for huge portions of how people intersect with the law on a daily basis. And so our discussion today is on that institutional feature of the judicial system. And like all big institutions, some might say like all big bureaucracies, change comes glacially to judicial practice. We like to tell our students that, oh yes, this is modeled on a practice that we inherited from English common law, and they nod knowingly without asking, what are you talking about? 15th century England is how we should organize our system of justice. But tolerate us, we tend to be backward looking. But every so often we get jolted. And I think that the COVID crisis is that kind of jolt. In Rahm Emanuel's famous terms, we should never let a crisis go to waste. And so we have been dealing with a crisis in the judiciary, in the administration of justice, and that's what we're going to turn to. And we have three great panelists. Let me quickly introduce them. Judge Rolando Acosta of the Appellate Division, First Department of the New York State Supreme Court, who is one of the key figures in the New York judicial system, trying to revamp appellate procedure and trying to figure out, in particular, how one responds to COVID. And the question that is going to keep coming up is what we get from that experience that carries us forward. Our second speaker will be Jennifer Ruiz, who is the chief of the New York City Law Department's Family Law Division. Now, this includes everything from incarcerated juveniles to child custody to all sorts of family welfare issues. And Jennifer supervises some 300 attorneys, I believe I have the number right, and is in charge of things that cannot be delayed. You know, great Supreme Court arguments, they can wait. But a child's welfare is something that cannot wait through the emergency. And finally, we have Colleen Shanahan. Colleen is a professor at Columbia. She recently moved to Columbia Law School. Her specialty is access to justice, with a particular interest in how the state court system is organized and administered in the United States. So without further ado, what we're going to do is ask each of our panelists to speak for about 8 minutes to start with, and then it'll be what has happened, and then I want to go into a second round on what's going to happen as a result, what will be kept once we are out of the emergency situation, and then we'll open up for questions. So Judge Acosta, thank you for being with us.
Thank you so much, Sam, for that introduction. And good afternoon to all of you. It's a great pleasure for me to be here, albeit virtually. I am very proud of how our court, the Appellate Division First Department, which, as many of you know, has jurisdiction over all appellate matters coming out of Manhattan and the Bronx. Of course, we also have auxiliary agencies like the Character and Fitness Committee that admits lawyers to the bar. I'm very proud of how our court and auxiliary agencies have adapted, to use Professor McKenzie's term, and responded to the pandemic. Unquestionably, in March of 2020, we were presented with an unprecedented challenge that I believe required us to take adjudicatory processes that have been developed over 120 years, apropos what Sam's introduction talked about. And basically would take those 120-year-old processes and we're required to replicate them in a virtual format so that we can continue to perform our core function of delivering quality and efficient justice. Now, before I deal specifically with the Appellate Division's response to the pandemic, I thought I'd spend a few seconds and give you a bit of context for many of the changes that have taken place in the First Department prior to March 2020. Now, I have been, since I started my legal career, I have been committed to access to justice and modernization since becoming presiding justice in May of 2017. Much of the work that helped in our response to the pandemic was completed before any of us had even heard of COVID-19. So for example, A few months into my tenure, we began live streaming oral arguments online and providing greater transparency and opening the courthouse door even wider. This system was instrumental in enabling us to conduct virtual court proceedings, such as oral arguments and admission ceremonies for new attorneys. We also spent a great deal of time in the past several years shoring up our IT systems generally, replacing antiquated servers, upgrading hardware and software. So in the summer of 2019, for example, which seems like eons ago now, we launched a new state-of-the-art case management system, which replaced our decades-old database and is frankly boosting our efficiency and providing more detailed reporting than ever before. It turns out that bringing the first department into the 21st century really paid off. In addition to enabling us to launch our new database, those efforts helped us seamlessly transition to a virtual court model, what I like to call AD1 2.0 at the beginning of the pandemic. So of course it wasn't easy. Like everyone, we had to retreat indoors by mid-March and figure out how to take, again, a 120-year-old court and make all of our operations virtual. So we first announced, for example, the emergency procedures on March 17 of 2020, taking the remaining March cases on submission and adjourning cases calendared for the last 2 weeks until the April term, among other things. But by mid-April, we had transitioned already to a virtual court model and resumed calendaring appeals, scheduling pre-argument conferences, admitting attorneys to the bar, and processing attorney grievance complaints electronically, which is the key here. We conducted our first virtual admission ceremony for newly admitted attorneys on April 27th, and our first virtual oral argument on May 6th. I mean, we started both with Skype for Business, where we're now using Microsoft Teams, which obviously is a much workable platform. Moreover, we have continued to expand e-filing, for example, which commenced in March of 2018. So in July of 2020, for example, we mandated e-filing all matters before the first department, except for original special proceedings and attorney matters. As it turns out, we have been as efficient using our virtual court model as we were with traditional in-person operations. So for instance, despite the pandemic, last summer, our court reduced the number of pending appeals, that is, cases that have been argued but not yet decided, to zero. Again, zero, for the first time in the history of the Appellate Division First Department. One of the promising data points that the new case management system has already revealed is that the court, for the first time, brought its average argument to publication time frame. That is the time that it takes between oral argument of an appeal to a published decision. And we have reduced it to under 30 days. I am not aware of any other appellate court that has such a quick turnaround time for decisions. And I believe that all litigants, from criminal defendant appellants waiting in prison to parties involved in protracted multi-billion-dollar commercial litigation, I am sure that they appreciate the level of efficiency for which our court has become so well regarded. However, there are consequences to the pandemic, with the loss of some of our judges and the lost time that we had to adjourn cases from March and April. We have accrual. We started September with 0 pending cases, but we started with about 1,100 cases that had already been adjourned and perfected for September. To give you a glimpse into what we do during normal times, with a full complement of 20 judges sitting in 5-judge panels, we are able to hear approximately 240 to 280 appeals per month. We are currently down to 16 justices, so that you can see what a challenging road we have ahead. But back to the question at hand. There's been a silver lining to the COVID-19 crisis, and I want to remain, glass half full in my presentation. But there has been a silver lining to this pandemic, in the sense that it spurred us to overcome many of our fears in technological advancement and to engage in forward-thinking approaches to handle our work in new ways. I have shared with you, and I'm sure David sent that out to each of the participants, an initial report of the Appellate Practice Working Group of the Commission to Reimagine the Future of New York State Courts, which I chair. That report outlines in detail all of the systems that we have put in place in the first department, and now which we want to replicate throughout the state, and obviously to develop the robust technology infrastructure that has served us well, and no doubt will allow us to face the continuing challenges resulting from this pandemic. Now, in response to the persistent question, so I'll answer it up front, to what our future looks like. It's impossible to tell, but I can tell you one thing, to be honest with you. It is clear to me that in crisis, there is opportunity. Moving forward, we continue to assess what substantive changes we can build on top of the already robust technology infrastructure in the first department appellate practice. Our goal is to continue to build these changes in the service of the public, including attorneys and litigants. Of course, as we build, we need to ensure that pro se litigants are not left behind as we increase the use of technology in our public-facing operations. While the courts have long been focused on improving our technological capabilities, things have not always moved as quickly as they should. Yet the pandemic crisis pushed that goal to the forefront, and we are making, I believe, great strides. I don't think, in conclusion, I don't think that we are going back to the old ways of doing things. With all due respect to those great titans of the profession that helped to build the systems that we have in the first department. I think that we are going to need a hybrid structure of in-person and virtual proceedings to continue to increase efficiency, improve access to justice, and to be nimble enough to respond to future crises. So with that, I will end my initial presentation. I look forward to answering some of the questions that you may have.
Thank you very much, Judge. I cannot avoid my role as a law professor, and so when we come back to you, I will want to press on some of the issues that you raised. For example, what has been the impact on pro ses? Is there more access for pro ses? We worry about digital divides. On the other hand, for working people, and given the high level of self-representation in the state court system, are virtual proceedings in fact beneficial? The silver lining point is an interesting one, and you don't want to jettison it because some people might be left behind. You might want to figure out how to bring them in, but I'll push you back on that in a second. So Jennifer, why don't you come from a slightly different perspective. It's a big institution also, but Judge Acosta has the luxury of the appellate docket. And sure, there's people in prison and so forth, but it's an appellate docket. You have to deal with crisis in people's capacity to survive on a daily basis. So why don't you tell us what your response has been in this situation?
Sure, thanks, Sam, and thank you, Judge Acosta. So as Sam had mentioned, I run the Family Court Division of the New York City Law Department, and our two primary areas of focus have to do with interstate and international child support, which does deal primarily with pro se litigants. Our larger part of our practice deals with juvenile delinquency cases, which I'm sure everyone is aware has changed Back 2 years ago, New York State became, unfortunately, the 49th state, but yet we have done it to recognize that youth under the age of 18 are not adults. And so now, as of actually October 1st, 2019, all youth under the age of 18 are now handled differently, in that all misdemeanor cases come directly to the family court, all felony cases originate in adult court. However, they can be transferred or removed by the court, and they are now called adolescent offenders. I raise that because my division in that side of our practice is in all three courts. We work in the family court, in the criminal court, and in the Supreme Court, because we have executed MOUs with the district attorney's offices across the city, 2 of which became effective during COVID, in order that we can assist with the cases that are going to be removed to the family court. And just as a point of reference, in the first year of Raise the Age, 83% of the cases that originated in the adult system were removed to family court. From our perspective, we're the prosecutors, we believe that means it's working, because of the fact that, you know, the primary focus of the legislation is that those cases which can come to family court will come to family court, and then only those of the most concerning will remain in the criminal court. So how did we adapt? As Sam said, we don't stop. So there is no such thing as a snow day in family court. I remember telling my kids that when I was young. It doesn't stop. It didn't stop during 9/11. It couldn't stop during Superstorm Sandy. Through any of the prior instances, the family court must continue, especially in the juvenile delinquency stage, because this is the one place where a youth can be held from their parent without bail. And so that does take up, in the rules of judicial priority, one of the fastest burdens and almost the highest priority under the law. And so the family court has to continue, and it did continue. In those prior terrible instances that I referenced, they were different. That was an event that occurred and then figuring out what to do. We haven't ended this event. And so under COVID-19, this became more of a challenge, because it wasn't so much of how could we address these cases in an emergency situation that would dissipate and we would go back, but rather that we are still in this situation and we have to move it forward as we go forward. Unlike the Appellate Division First Department, I don't think many city agencies were quite as prepared. We all had to transition our entire workforce to home within less than a week's time. And that required a great deal of work, no matter what division we were in the law department. At the same time, we had to continue our court operations. And so what we found that in terms of our own division, throughout this period of time, that some form of normalcy that we could try and hold on to, as well as values in making decisions going forward, was what we would work for. So in terms of something that happens every week, the Chief Judge of the state of New York sends a message to everyone involved in the courts of New York State every week. And I had sent to David, if people are interested, her 11-9 message, which really does deal with what was happening in family court across the state. And so we used that to kind of base ourselves as to what was going to happen in terms of the courts. Basically, what happened was extraordinary. Not perfect, but extraordinary. And what we did was stakeholders from across the court, city agencies, honestly from across the table, whether they were our attorneys for the child, which is the name for the defense attorneys, or whether they were prosecutors, really had to come together. We had to decide what we could agree on, because we didn't have time to argue about things that we didn't have the ability to do so. And so what the New York City Family Court did was, although it is a court in 5 boroughs, and just to explain, it is actually governed by the CPLR, because of the fact that the idea in juvenile justice is for there to be different rules than in criminal justice. So just as a point of order for law students who may be here, our court is governed in first by the Family Court Act, which is governed by the CPLR, and can bring in the CPL only if it's intentionally brought in the Family Court Act. So these are the different laws, again, that are governing our cases. It's a court in 5 boroughs. They immediately centralized. And luckily, back in 2008, New York City had done a model for this because none of the other counties in New York State did this. However, New York City began a weekend holiday court procedure. And that was because prior to 2008, if you had a youth who was arrested with an adult, that youth would wait until Monday morning to have their case heard, where the adult would hear it on Friday. Use that model, centralize the operations, and that's how we've gone forward. As Judge Acosta talked about, there's been tech issues with regard to Skype for Business versus Teams. In family court, there was a specific issue with regard to voice recognition technology, as everybody was talking, but the technology wasn't picking up who was whom, and the court has worked on that. And we have had virtual hearings in our child support practice. There's been about 116 hearings. However, at the beginning of the emergency, which our practice is governed greatly by the executive orders of the governor, the court was directed to determine essential matters. Juvenile delinquency cases in custody are essential matters. However, the filing of child support petitions are not. So while child support cases that had previously been filed are continuing, the child support filings have not, which has significant concerns for those who are filing for child support because their arrears are dated by the date of filing. I do want to talk about one specific thing that we did, and it has to do with the values. As we came together in our own office around the beginning of the pandemic, we knew from the science that it was a very dangerous situation for people who were living in congregate care. At the time, we are responsible because we make the applications to request that the court hold youth pending their proceedings. The people who were in detention at the time were in detention because the court made an order under the law based upon two criteria, which is whether somebody would reoffend and or whether somebody would not return to court. That was the right standard. Those orders were sound. What we did as an office was with no input from anyone, took it upon ourselves to look at every one of our cases of youth in detention. We used that standard, but we added another piece. And we added the piece of the danger to the youth of being in congregate care during this pandemic that we knew nothing about. So we looked at the case as to whether or not they could be safely released back into the community. We worked with the Department of Probation, who would put some services in place, as well as MOCJ, which is the Mayor's Office of Criminal Justice. And as a result, we were able to decrease the initial population by more than 50%. Prospectively going forward, we knew we had that same responsibility. And so each of the cases coming in since that time has that heightened look at whether or not a detention of this youth is outweighed by the danger of the COVID-19 pandemic. And we have similarly kept the population to a minimum, and we believe that we can keep that going forward. Other services that we were able to harness because of Raise the Age were things such as the Division for Youth and Child Development, independent living beds, as well as Covenant House, which became involved for the first time in the juvenile justice system, as they had previously not accepted youth under the age of 16, but they were willing to define homelessness as a youth who may be in custody. However, we are prepared to release them, but they don't have a resource to which they could go. So those are some of the things that we have done with regard to COVID-19. And I look forward to the further discussion of perhaps what can be brought forward. Thank you.
Thank you, Jennifer. And it's not within the scope of this panel, but you raise a fascinating point about some of the collateral consequences of rethinking things in light of COVID. Obviously, the question of mass incarceration in our society is a concern to many of us. And the fact that that COVID forced a reevaluation of the criteria that are being used for juvenile detentions is an indication of something broader that's going on in many jurisdictions of having to reevaluate the mass incarceration question because it focuses more immediately and graphically on the consequences of detention not just to the society, but also the costs and benefits localized on the individual. That's just a fascinating set of issues. So Colleen, perhaps you can step back a bit and give us some, maybe have some data even, but the broader sense of, how is this working? How is it affecting access? What are courts doing? And in particular, when we spoke earlier, I mentioned that I have been quite intrigued, depressed, whatever it is, with the transformation of the civil docket in the state court system to becoming extensively on the civil side, basically collection cases or debt foreclosure cases of one kind or another. And has this created any space for rethinking how the courts are handling these kinds of cases? So let us know.
I thought I would just start with framing the scope of this, in particularly nationally. So as you heard Sam say earlier, about 95% of civil cases in the United States are in state civil courts. So despite our instinct as law professors to talk a lot about federal law, the balance of business these days is in state civil courts. And we don't have perfect data, but our best data tells us that about 3/4, about 75% of those cases have at least one party without a lawyer representing them. So folks are in this alone to a large extent. And our best numbers pre-COVID were that there were about 300,000 cases a day in the United States on these collective state civil dockets. Now, this is a range of cases, right? This isn't a singular docket anywhere. This certainly includes private party to private party disputes. Some of those are what we think of as the traditional counseled adversarial disputes that our procedures are designed to handle. A number of those private party disputes fall into questions of debt and collection in different contexts that increasingly have unrepresented defendants with concerningly high default rates, where those defendants don't even show up to court to litigate their case. But these civil courts also handle a lot of the cases that Jennifer just talked to us about, cases where either the government is explicitly a party, like child welfare dockets, or dockets where the government is a meaningful presence and source of power. And the prime example of that is domestic violence cases, where although we docket those cases as one party, one individual against another, the role of the government is meaningful. And so what this means is that from a bigger perspective, I think it can be helpful to think about courts as an ecosystem beyond the judges and court staff, but certainly including them. Sort of all of the actors that make these institutions function and how those actors collectively have adapted to the coronavirus as a crisis. And I think one thing that we're seeing that is, as Judge Acosta sort of previewed, is a continuation of what was already happening, although maybe we're seeing it more vividly now, is informal adaptation, informal problem solving, especially for unrepresented litigants' problems in these courts. So before COVID, it is absolutely the case that state civil courts, judges, staff, lawyers in those courts, non-lawyer advocates who give advice in the lobby, certainly researchers like myself, were sort of waving our hands in the air saying, maybe these courts aren't the best way for people to solve their problems. And I think both the freezing of some of these dockets and the adapted operation of some of these dockets are showing us that in fact this informal problem solving may be the path forward. And so I'm going to give just a couple of examples, and we can talk about more in the sort of second part, which I think sometimes this question of opportunity and what remains is the most compelling thing. But here are two examples of this that are happening as we speak. So one is with some colleagues over the last couple years, I've been doing a study in 3 different states of domestic violence dockets. And one of the things we found in our data is this unrecognized story of non-lawyer advocates, not just from outside the court, but actually within the court, being relied on as judges to assist parties in these cases in ways that formal procedure does not provide for. Now, this is something that those of us who have handled a protective order case find unsurprising, but on a systemic level, it's actually something we haven't paid much attention to. And in fact, it may well be, and this is sort of cheating into the last panel's topic, but it may well be an insight into the regulation of the legal profession, right? In fact, judges have found value in empowering non-lawyer advocates to assist litigants. Now, that's something that was happening before the coronavirus. So what's the shift that's happened? Well, one thing is we're seeing it more vividly. It's becoming more explicit. But another is that same informal experimentation has taken on new tools, as you've heard. So it's not just video appellate argument. It's also, for example, as part of a collaboration with Northeastern Law School in Boston, the domestic violence courts in several jurisdictions there have developed an app that both allows potential plaintiffs seeking a protective order to reach out to non-lawyer assistants to both do safety planning and to go through the filing process with the court, and also for the court to connect with those individuals in a way that does not further enhance their risk of violence, even when the physical courthouse is closed. So that's an example of where, just getting on video isn't going to address the litigant's needs. In fact, there are more complicated needs in the problems that cases provide. Another example is one that stems from actually work my clinic students at Columbia have been doing here in New York at the Red Hook and Harlem Community Justice Centers, which are community courts. A piece of their work is housing resource centers and housing dockets in those community courts. So one piece of those dockets is housing repairs. So for NYCHA, for public housing residents seeking repairs to their apartments. Now, those dockets have largely been closed, frozen since the pandemic began. But nonetheless, residents still need their apartments fixed, sometimes in dire ways. And one set of adaptations has been opening up pieces of the docket for the most critical problems. But another adaptation has been, even though the court case is frozen, informal collaboration between the Housing Resource Center advocates at the courts, the NYCHA and Housing Authority actors who would sort of be the other party in the court, and the housing court itself to negotiate resolutions to the problems that otherwise would be resolved through a formal court process. So I think, one of the lessons here is just reinforcing that that access to justice is about the tools, right? Can we use video? Can we use phone? Can we use an app? Can we change the way we schedule our dockets? Can we change when physical presence is required? But it's also about how we conceive of the role of courts and the particular actors in them. And I think a piece of that is important to surface is that in so many ways, these smaller scale questions are about our view of inequality and how it surfaces in state civil courts. Are there, I share the silver lining view, right? With complications and always as an academic and urging for more and better information and understanding. But I think one of the things that's happened here is we are seeing more clearly and perhaps embracing more wholeheartedly the ad hoc approaches that have been going on or evolving all along. And so in that sense, I look forward to what comes.
Thanks, Colleen. So let's continue with this silver lining theme. It's always great to be, in general in conferences, you want the first panel to be optimistic and the last one to be the gloom and doom, so that, or maybe it's the other way around, but who knows, maybe we'll turn out to be the gloom and doom and everybody else has had a great time through COVID. But Judge Acosta, let me ask you a couple of questions. I do some appellate arguments from not infrequently, and I did one in the Ninth Circuit maybe a month ago or so, maybe less. And one of the things that struck me was that the Ninth Circuit's in California, and I'm sitting in Connecticut right now. And I got up in the morning, I had to put on a jacket and tie, but I argued, and then I was done, and then I turned and walked right out that door, and I was home. And cost, wear and tear, tremendous economic savings across the board. On the other hand, I have to say, quite frankly, it's an inferior experience as an advocate. I suspect it's an inferior experience as a judge. And we can very easily fall into the trap of saying, oh, it's not as good as some part of it, especially when we've accepted that for an hour argument, you fly to California and fly back. And so basically take 2.5 days in order to handle a 1 hour argument. So the question is, if one consequence if that it's good enough and the costs are coming way down, that's got to be a big access to justice point. And you know, the legal institutions are all conservative by nature. So I'm sure you're hearing from your colleagues the way that I felt of it's not as good as appearing before them, the drama of the courtroom, the majesty of it, all that's lost. But give me a break. How much are we willing to pay for that? And how does the judiciary think about that? And then the other small piece I want to ask you about in particular is what Colleen just mentioned about the pro ses. Have you noticed, because we've heard anecdotes, but I haven't seen any data on this, is there a greater level of pro se participation now that you can take an hour off from work rather than take an entire day or 2 days to do this? So
I know the answer to that is clearly yes. I mean, I in my initial presentation, I talked about the importance of realizing that we're going to eventually go to a hybrid system. I mean, I miss my colleagues. I miss folks like you, Sam, arguing cases, and for me to be able to look you in the eye and engage in probably the most profound legal issues that come before the first department, which many say is the best intermediate appellate court in the country. I think, however, you know, we need to be able to be nimble. I think there has to be a combination of things. You take, for example, the live streaming of oral arguments in the first department. I mean, it has been incredibly great for pro se litigants. It has also been a very important matter for access to justice. It's really important for the credibility of the court system and our democracy, for people to be able to see how the sausage is made, to coin a phrase. It's important, you know, in the past, when we had in-person oral arguments, you have, other than the occasional NYU law class coming in and, you know, I get to present to them and engage them a little bit, or maybe a Columbia Law School class, I present, you know, cases that are coming up, the issues that are going to be argued, etc. And maybe a family of a defendant whose case is being considered on appeal, maybe a reduction of sentence, etc. Other than that, our beautiful courtroom, which you see in the background, this is why I put it on, it was empty. The class is really an empty process. It's great for the litigants. It's a wonderful thing to be able to do things in person, but access to justice has in fact improved. I think just with respect to how we respond to pro se litigants, I've created, as part of this process of bringing the Appellate Division First Department to the 21st century, I created a task force comprised of different level of staffing, including judges in the first department, precisely to make sure that we guard against creating systems that are not responsive to pro se folks. I mean, that's something that I'm really committed to. We have clerks in the clerk office that respond directly to any questions and guide, hold hands with pro se litigants to make sure that they understand what, in fact, are very complicated, complex processes that sometimes lawyers themselves don't quite understand, or sometimes just don't read our rules. They don't go to our website and read it.
Can I interject one question on that? Because what the data that Colleen gave indicate that the state courts are changing, at least in part, their function in our society and on the civil side. And so the idea that they're there to adjudicate tort cases where, you know, one side has Mel Belli and the other side has Clarence Darrow or whatever, that seems not to capture the picture of what's going on. It seems to be largely a debt-oriented feature of a very difficult aspect of our society. It seems to me that that what you're describing is not just a confrontation with the cost effectiveness of business as it was done, but you're reconceptualizing what you do, because this is forcing you to come to grips with what the civil court system has become.
Absolutely, and remember, this is something that that I've been committed to. For example, when Colleen talks about informal problem solving, one of the things that I was involved early on in my judicial career. In fact, I am the justice who created the problem solving court, the Harlem Community Justice Center in Harlem, because I am committed to that. When I was got out of law school and litigated for the Legal Aid Society Civil Division, I represented folks who had difficulty penetrating that very system. So my commitment as one of the leaders in the court now, for example, just take what we do. We've given, as part of the judiciary budget, over $100 million a year that goes to representation of litigants in housing court and other civil courts. That shows commitment on the part of the chief judge and on part of our system. I think one of the things that I've been, in fact, I wrote a nice piece in the Law Journal regarding the merger. I know that some folks have questions about whether merger will deal with the issue of diversity, et cetera. But one thing, and I'm talking as in my hat as a former legal aid lawyer, one thing that is very clear to me is that, an antiquated system with 11 different trial courts with overlapping jurisdiction, litigants, pro se litigants, have no idea whether they need to go to federal court or whether they need to go to Supreme Court matrimonial part, to family court, to where do I go to deal with this issue? And most of them are pro se. So part of what we need to do is look at the system. Part of it is doing what Colleen suggested, is getting a more informal process to deliver justice. That's what I think Red Hook does. That's what I think the Harlem Community Justice Center is. It's the whole idea of problem-solving courts that basically deal with a lot of really non-legal issues that are brought by litigants to the court system. And that's the reason for the creation of those courts. The traditional court system is not responsive to the real needs that are brought by youth and by tenants in Harlem or East Harlem or in parts of Brooklyn, etc. So you're right, we need to get more creative, use technology, but not forget that technology is only part of it. We need to make sure that whatever systems take advantage. This is why I talked about crisis as opportunity, right? It gave us an opportunity to move from, word perfect to word, so that everybody can access the systems that we have that are based on Office 365. But it's also making sure that those systems, and this is something that's happening in the housing court, for example. I know that we're going to be creating an entire infrastructure, and Justice Cannataro has done a great job in presenting to us at the administrative board, and we approved it. The administrative board, just 2 seconds, is a body of the 4 presiding justices of the appellate division with the chief judge, and we basically forge policy for the state system. So it's important that we begin to look at, not every tenant can go to housing court and start an HP case. They got to miss work in order to start an HP action, in order to get repairs done in their apartment, or go and interpose an answer in a non-payment proceeding or holdover proceeding. So we need to really build, take advantage of electronic technology systems, e-filing, for example, in the housing court. Some people thought, oh, e-filing will never work in housing court. Actually, I have found that pro se litigants are really getting benefited. At first, I was reluctant to believe it. Sort of my legal aid cynicism comes in sometimes and say, oh no, Doña Juana in East Harlem or in Washington Heights is not going to have access to technology, is not going to be able to take advantage of a lot of the things that she needs to take advantage of. But actually, it's better than having Doña Juana having to go down to 111 Center Street in order to get repairs done. Now she can either through a friend's computer if she doesn't have any, or through a smartphone, she's able to interpose an answer and engage the court in getting justice for herself. So I'm really excited, as you can note from.
Yeah, it's great that you're so excited. But I want to give Jennifer the chance to play the skeptical role here, because I do a lot of judicial conferences, and every time that appellate judges talk about how innovative and effective they are, all the district court judges roll their eyes like, yeah, if I had only 100 or 200 cases a year, yeah, I could be effective also, and give me a break. Or when the Supreme Court of the US says it's working very hard on 70 cases a year. So what Judge Acosta is describing is coming to grips with the technology. Oh, I'm sorry, I was supposed to do something and I forgot to. I have to announce something. What will follow is either the launch codes or the CLE code. I didn't get an answer as to which, but you have to write down CCJ CC10. CCJ CC10. I'm sorry, I forgot to do that. But anyway, Jennifer, it is more penetrable through the technology. I think that's the conclusion that Judge Acosta is putting forward. Do you agree with that? Is that meaningful for the client base that you have to deal with, for the kinds of cases? And what else do you see? I mean, you really raised a very provocative point that, again, takes us a little afar, but on this idea that we're revisiting who should be in custody even. What else do you see being revisited that would help the kinds of cases that you're concerned with?
But Sam, I have a really dear friend who was with the Legal Aid Society. She's now a family court judge. And she used to challenge anyone who was doing something. And she would say, is that based on family court law, LAW, or family court lore, LORE? That's the way we always do it. And I think that this is the moment that really challenges us on that. This is the way we always do it. You spoke of your—
You realize that in Brooklyn, those two are the same word.
Yeah, I was born and raised in Brooklyn, so I had to really practice that pronunciation. You mentioned your trip to California and the time that it takes from you. That happens to family court litigants every single day. And even in the juvenile delinquency side, even though they're not the party, they're the parent of the party, right? Or they're the guardian of the party. And people will come and will remain for the day to have a case adjourned, or for motion practice, or for different things. And there's a big debate going on whether or not trials should be done virtually. Now, we don't have juries in family court. I was in the Brooklyn DA's office, and of course, juries is an entirely different issue. But can a bench trial be done virtually? Can the accused rights be properly, maintained in a virtual trial? So taking away trials for the moment, it really would seem as though anything short of that can be done, as Judge Acosta said, in a hybrid system. If something is on for a motion for a conference that doesn't require an in-person appearance, then can that be done virtually? The thing with the family court law, LAW, is there's still a requirement of personal appearance when not held by the executive order. So that would have to be a change to the law that would permit this to happen. I will say, I mentioned, we've done over 100 hearings in the child support practice, the majority of which with pro se litigants. And anecdotally, it has been better. It goes against the nature of the proceeding to say, take a day from work, come and wait in the courthouse and have your child support case heard. People have been actually participating from work and have been, actually being able to walk away, find a space and participate in their hearings. So I would think that, it's great the appellate division is doing it. And I think we should follow and really be looking at what do we have to be there for? The same with work, with my staff. What do we have to come into the office to do? And what can be done in a way that still, without, being at the end of this, maintains the safety of people to the best that we can.
So let me ask you a very specific question on this. There is, of course, a concern about digital divide and so forth in our society. But there's also socioeconomic divides on who can access a system with high costs. And I don't know data, but I'm starting to come of the view, and I'd like your experience because this is just anecdotal, but I'm coming to the view that in fact access is increased by digital mechanisms because so much of our population has access to a smartphone. Either they have it or their kid has it or their cousin has it, but basically most overwhelmingly of our population has access to a smartphone. So I think that the cost burdens of having to take a day to go to court to file a motion or something of that sort far outstrip the digital questions. And maybe, we can use public libraries to try to, or public spaces to try to help people with that. But I think that holding back on non-essential in-person activities, maybe a jury trial, we'll talk about that later in the day, but it seems to me that this is a wake-up call that the system is sclerotically too expensive.
Yeah, and the court, and again, I referenced the Chief Judge's message, and there was also a report that was done on the online state of the court system. Basically, what has happened, and it started in actually the Brownsville Community Center. We met with Judge Richardson Mendelson, who is a judge who does Justice Acts initiatives about access for pro se litigants. And in fact, they are standing those up through CCI, which is a Center for Court Innovation. And again, began in Brownsville. Red Hook and Harlem may become available. They are ambulatory courts now, unfortunately, because of COVID. And they've also reached out to faith-based organizations across the state who don't close when libraries close and who may also offer that. But I agree, the expense of missing work, not only the expense of getting paid the day, but really jeopardizing a job because you can't be there, is certainly something that for certain appearances should be made available. There are certain areas of the city, certainly there was a lot of media that I'm not involved in, but that homeless shelters were having some difficulty with regard to internet access. But other than that, really standing it up around the community and allowing people that access, I think, is something that really must come forward from this.
Just 10 seconds, Sam. That's one of the issues. The issue of cost is something that I'm examining in that appellate practice working group that I mentioned to you before. Clients are no longer willing to pay a printer $30,000 and then to try to flight their lawyer from California to New York, pay for all of the expenses related to that. So when they get a bill for $50,000, $60,000 on what seems to them like a straightforward case, that's an issue. So when that lawyer on pro habeas cases where, we need to fly a lawyer from godforsaken place in the world to come and argue in the first department. That's where virtual operations really work. With respect to us access to technology, the very reason that problem-solving courts were started and we spearheaded that we're one of the champion state in that area is to make non-traditional approaches to delivering justice. So, you know, Doña Juana can go to a kiosk or to, you know, East Harlem or to an ambulatory access to internet and have somebody there help her interpose an answering housing court, for example, rather than in some instances come to 111 Center Street, which is frankly a little too close for comfort, to the INS, to ICE at 26 Federal Plaza. I know that was an issue that I always had with clients back in the day. So it's something that we need to consider.
So it turns out that I'm originally from Argentina and my grandmother's name was Juana. So every time you invoke Doña Juana, I think my grandmother got involved in this and I can't figure out why. But Colleen, you're always the source of terror for us because you actually know stuff, whereas the rest of us are just kind of guessing from our experience. So is this right? I mean, can we make a leap here that's going to significantly change access to justice?
Yeah, so first I'm going to get a nameplate once I go back to my office that says source of terror. So I think, you know, the overarching answer is, which is true of so much of access to justice research, we don't actually know enough. But I think I want to sort of pull apart two different questions in this tech and access to justice conversation, and then say a little bit about what research we do have and what's ongoing. So the first part is technology is a way to get in the room, right? So this is just, do people have access to a smartphone to attend their hearing, right? So that's sort of one layer. But the other layer is a question that we've been grappling with, and the conversation about problem-solving courts is part of this. Can technology be a way that facilitates unrepresented litigants' ability to participate in the justice system? So it's not just getting in the room, but once you're there, how do you know what to do to advocate for your own interests? And so as to the first, as to just the pure use of technology, you know, we don't have great data. A lot of organizations, both on the academic side and on the sort of institute side, like National Center for State Courts and ISLES, which is the institute out at Denver, are scrambling to get data on just this question of, you know, is it true that litigants in housing court aren't defaulting as much because they can participate on their phone as opposed to having to go physically to a court? So that's an open question. And, you know, I think we're all sort of stewing in anecdotes. And I'll say in variations of this conversation, I've heard variations on anecdotes. That's often the nature of this work. As to the
we are law professors. We trade in anecdotes.
I know, we're experts
don't be
of anecdotes.
Don't be too skeptical here.
But as to the sort of participation in the process, there's really only one study that I know of that breaks these questions down. And the good news is it's leading to more studies of the current situation. And that study's by Professor Ingrid Eagley, who's out at UCLA and studies the immigration context. She actually did a marvelous study of quantitative and qualitative data around remote immigration hearings. And one of the things that her study identifies that I think frames some important questions for studying our current circumstance is that her data showed less engagement and participation by unrepresented litigants in the video process. And here's what she meant by that. She meant that judges in these remote hearings actually provided less information and advisement of rights to clients, to litigants, that litigants were less likely to request or engage with offers of legal assistance, and that litigants exhibited more confusion about what was going on, what their rights were, what the process was in the hearings. And so that bumps up against these questions we've been grappling with in person. about unrepresented litigants in the civil access to justice question. I mean, talk to any state civil judge, and they're going to tell a version of how much they have to do to help an unrepresented litigant in front of them, or how much their deputy or the court clerk in the hall has to do. And so these same
Colleen,
questions manifest remotely.
Colleen, let me push you on that though, because I want to make sure you're making an apples to apples comparison. That's the litigant who shows up in court versus the litigant who is participating by smartphone. But there's a universe behind each of them of the litigants who never show up in court and the litigants who never show up on the smartphone. And if it turns out that the universe of the people we don't see is much smaller in the tech context, then it's not an apples to apples comparison.
So it's not a comparison. I'm saying they're separate questions. So our first question is, are more people able to show up on their phone than they are at Center Street, right? Just that level of access. And then I think a different question is, for those people who show up, the same set of questions that we've really been struggling with about people in person apply, but perhaps in variation with that remote participation. And there are challenges unique to the remote circumstance. If a judge in a courtroom sees a litigant struggling, there are largely ad hoc solutions we've developed to help that litigant. That might just be simply judicial explanation based on a perception of body language. That might also be a habit, formal or informal, of referring to a court clerk to say, take a minute, I'm going to recess. Why don't you go out in the hallway and talk to this clerk to get some advice about how this goes? We don't say advice, to get some help with how this goes.
So let me
can't happen on your phone.
Let me pose to you a question that came in from an audience member, which is, if the phone is being used in that fashion, then the phone is in effect giving first cut legal advice, right? Because it's channeling you one way or the other. How do we deal with the competence level of the phone? Meaning, do we have to have CLE for the underlying program? How do we guarantee that you click the first button and it says, oh, you belong in Colorado State Court, and why? But it just a glitch. How do we actually, when there's a lawyer there, obviously person to person, you can correct things. What's the mechanism that you're seeing here?
Yeah, so I think what's happening right now is because the technology is an overlay because of COVID, people are already engaging with the court through a formal mechanism, right? I'm going to go, I know I've got to file in the traditional way in New York Housing Court for my child support in New York Family Court. And then the technology is sort of presented by the court system. So those threshold questions aren't quite arising in that way. What is, I think, the future question, I don't think we're at this level of sophistication right now, but I think the future question is going to be, do we actually use technology to develop intermediate steps? So let's say I go file for child support, I opt in to remote participation, let's say, and so the court, instead of just saying, here's your Microsoft Teams link, there's actually an intermediate step, which is, here are a series of questions, an app that allows you to give the court information and receive information about how best to participate in this child support hearing, or maybe even resolve this without a hearing before we get to that Microsoft Teams link. And I think that's the next wave. That sort of integrates reaction to the coronavirus crisis with app-based legal assistance that's been developing for years here. And that's the place where I think we're going to face the real substantive challenges about how unrepresented litigants engage using technology with the court systems. Oh, Sam, I think you're muted.
I'm sorry, Judge or Jennifer, do you want to weigh in on this? Because we only have a couple minutes left, but it seems to me if we finish on the concept of forward-looking, how are you going to deal with the problems of misrepresentation or malrepresentation in a world that is largely devoid of human contact?
Well, when I litigated in behalf of tenants for the Legal Aid Society, one of the things that I found, I found the processes that existed in housing, in person, in housing court, led to really ignoring a lot of the litigants that were present. You show up, you take a day of work, for example, as a tenant, and you used to go in and you just plop yourself at 111 or at 851 Grand Concourse in the Bronx, and you just wait until your case is called, which can be an entire day endeavor to engage the court in that process. That is no longer the case. You can actually set up technologically appearances, staggered appearances by litigants that you were not able to do before. I think that what Colleen is talking about is really a hybrid process. It may be that the best way to proceed is to give folks the ability to access the system in person if that's how they feel they're going to be heard better, or they're going to have better access to justice. But give folks who have otherwise defaulted or not be able to take a day off from work to spend in housing court or in family court, give them the ability to engage with the court through a Teams application. I believe that's I think the wave of the future. You're right. I don't think everything is going to be in person. I don't think everything is going to be virtual. I think we really need to begin to grapple with what is the best way of delivering justice in these circumstances.
Hey, Jennifer, you get the last minute.
So Colleen mentioned the app in Boston, and it just reminds me of what actually happens now in New York City Family Court in domestic violence cases. Safe Horizon is an agency that works directly with petitioners in those cases. And similar to what I'm hearing about the app, it's a person who's not necessarily an attorney, who knows the practice and who can guide somebody in the filing of a case, which still goes before a judge to determine, the propriety of the filing. So I think we have that in some ways and in other advocacy organizations. And, just a word on alternative dispute resolution. We have that in family court as well, right? In terms of diversion services, small claims court, which is in family court. I think there was a pilot over COVID in Manhattan to handle those cases. I've worked as an arbiter in small claims. So I think it can be parsed out. I don't think everybody has to wait every day to go before the court for every purpose live. And so I'm excited to see what comes, because you do see lines of people going into housing court, going into family court, going into Supreme and civil court. And perhaps that could be alleviated based on what we've learned.
Well, thank you very much. We ended up directing ourselves more toward the virtual world becoming part of the cost realization in our court system. And I think this is an important issue. There were several questions about the mechanics of trials in virtual proceedings, but there are other panels that will address that. So let me just thank our participants, and you can hear the rousing ovation from the masses gathered behind me. It's one of the truly horrible things about these virtual conferences, that you give a presentation and then you're done and you're gone, and you're like people who used to be on Celebrity Squares. All of a sudden they're no longer there. But thank you very much. This has been really interesting conversation.
Thank you, Sam. And as a future practice point, I think we will have to have an applause recording for our virtual conferences. That was a wonderful panel. And we are going to move directly into our next panel. We will take a short break after the second panel for just a couple minutes, but we're going to move directly into the next panel. So